Hello and welcome back to the Way to Native Chronicles. Today let's explore a very specific question. Do First Nations in Alberta, particularly those under Treaties 6, 7, and 8, have a legal veto when it comes to Alberta separating from Canada? This is an important topic and one that deserves clarity. Now, before we dive in, I want to give you a quick heads up. No matter where you stand on the issue of Alberta separation, you might find some of the facts brought forward in this video a bit unsettling, if you don't mind the pun intended. That's because this topic pushes into a legal, historical, and constitutional territory that most people rarely think about. I know that for myself. Before researching into this subject in greater depth, I began feeling quite confident in one view and have come out of the process with a far more nuanced take on the subject. So, if you're not afraid to challenge your own beliefs, let's begin. The short answer to the question posed could be said to be no. First Nations do not have a formal veto in the way that people might imagine, like casting a single vote that cancels a referendum. But that's not the whole answer. Legally and politically, their role is far more powerful than many on the pro-independence side appear ready to admit. First, let's cover some of the basic facts. What the treaties actually say is Treaties 6, 7, and 8 are nation-to-nation agreements between the Crown and Indigenous nations made under the assumption that Canada would uphold its obligations. Those treaties were not made with the provinces. Alberta didn't even exist when they were signed. At the time of their signing, well, Canada also didn't exist in the form it is today. It was a British colony, not an independent nation. The treaties were actually made with the British Crown, Queen Victoria specifically. Then there's the matter of consulting versus obtaining consent when it comes to these matters of separation. The Supreme Court of Canada has ruled that governments must consult and accommodate Indigenous peoples on matters that affect their rights. But there is also the principle of free, prior, and informed consent, FPIC, as enshrined in the United Nations Declaration on the Rights of Indigenous Peoples, shortened for UNDRIP, UNDRIP, which Alberta and Canada have both committed to. This raises a key legal and philosophical debate. When making decisions that affect First Nations interests, is consultation enough? Or is actual consent required? Under Canadian law, particularly in decisions stemming from the Supreme Court, consultation is typically required where Indigenous rights may be affected. This involves meaningful engagement, but does not necessarily give Indigenous nations the power of veto. However, under UNDRIP, which Canada has adopted and is in the process of implementing, the standard is clearly free, prior, and informed consent. This higher standard implies that for actions like Alberta separation, which would directly and profoundly affect Indigenous treaty lands and governance, Indigenous peoples must not only be consulted, but they must give affirmative approval. That said, it's also important to clarify that UNDRIP does not automatically bind Canadian law in and of itself. It is an international declaration, not a treaty, and as such, its provisions do not override Canadian statutes or constitutional law unless explicitly put into legislation. However, in 2021, the Canadian government did pass the UNDRIP Act, committing to align federal laws with the declaration. This marks a shift toward integrating UNDRIP's principles, including consent, into domestic law. Alberta, too, has acknowledged UNDRIP, but is not yet legally bound by federal implementation. So, while UNDRIP does not yet carry the same enforceable legal weight as constitutional rulings, its moral, political, and increasingly legal influence is growing. especially in areas that directly involved Indigenous rights over land governance and sovereignty. Consent, therefore, remains the more appropriate and morally defensible term in this context, particularly given the evolving expectations Canada has committed itself to and the clear language of Indigenous rights frameworks. This likely means that if Alberta wants to achieve an independence that stands the test of law and legitimacy, it will have to negotiate directly with First Nations and secure their active, informed, and voluntary participation, not just as consulted parties, but also as consenting and equal stakeholders. And that might just be the best safeguard First Nations have. Digging deeper, what if Alberta separates without First Nations coming along? Let's examine that possibility. If First Nations withheld their consent, could Alberta become a separate nation anyway by proposing First Nations remain a part of Canada? This idea, while complex, is not impossible. If Alberta were to unilaterally declare independence without the full support of Indigenous nations whose lands fall under the protections of Treaties 6, 7, and 8, those First Nations could assert that their lands remain within Canada, regardless of what the surrounding provincial government decides. This scenario could be justified on the grounds that Indigenous nations could invoke international law, Canadian constitutional principles, and their treaties to claim continued Canadian allegiance. Now for some potential consequences of this fragmented scenario. If this happened, Alberta's new national boundaries would be disputed and quite fragmented, with patches of Indigenous land remaining under Canadian control. Infrastructure, law enforcement, and service delivery would become very complex across those overlapping jurisdictions. Alberta's legitimacy on the international stage could be weakened by internal conflict and unresolved territorial claims, perhaps similar to what we've seen with the Free Palestine protests. Due to their new standalone situations, First Nations could end up in a stronger negotiating position, possibly gaining greater autonomy from the federal government. Any vision of Alberta separating should realistically account for the possibility that large portions of its current territory may not go with it, unless Indigenous nations freely agree to that arrangement. Any future built on ignoring that fact is likely to be an unstable one from the start. Now let's continue on with a slightly different subject about how informed the public really is. Does anyone even read the original treaties? Have you read it? You who are watching? Let's take a look at why some claim First Nations leaders are greatly overstating their case, relying on the public's general ignorance when it comes to what's stated in the treaty documents. I'll provide a link to the full text of the Treaty 8 in this video's description. I suggest you try the following experiment. With the treaty loaded on your computer screen, do a search for the word CEDE, C-E-D-E. If you do so, this fifth paragraph of the treaty will come up that reads, "And whereas the said commissioners have proceeded to negotiate a treaty with the Cree, Beaver, Chippewan, and other Indians inhabiting the district hereinafter defined and described, and the same has been agreed upon and concluded by the respective bands at the dates mentioned hereunder, the said Indians do hereby cede, release, surrender, and yield up to the government of the Dominion of Canada for Her Majesty the Queen and her successors forever all their rights, titles, and privileges whatsoever to the lands included within the following limits." By the way, the capitalization shown here is not mine. That's how it appears in the original text. This clause in the treaty, then followed by definitions of the areas ceded, is often cited as evidence that First Nations fully surrendered all rights to the land. It is, however, crucial to recognize the following two key factors. Number one, as stated in this video before, the surrender was made to the Government of Canada, not to the provinces, and certainly not to Alberta, which did not exist at the time. Number two, the surrender clause was not absolute in practical effect. The same treaty also guaranteed ongoing rights to hunt, trap, and fish throughout surrendered territory. These rights remain constitutionally protected today and restrict how the land may be used even by the province. So when First Nations say the land is not just Alberta's to take, they're not disputing that Alberta owns and administers much of the provincial crown land, but they are pointing out that this land is encumbered by historical, constitutional, and international obligations, and that even though First Nations agreed to cede the land to the Crown, they did so with conditions that still legally and morally bind Alberta today. Alberta may have legal title to Crown land under the Natural Resources Transfer Agreement of 1930, but it does not possess absolute authority over lands where treaty rights continue to apply. This distinction reinforces the idea that Alberta cannot unilaterally assert full control over all lands within its current boundaries, especially in a scenario involving separation from Canada. Alberta is still subject to constitutionally protected Indigenous and treaty rights, not just within reserves, but also when it comes to hunting, fishing, trapping, and cultural access rights. The Supreme Court of Canada has confirmed in multiple rulings that treaty rights are constitutionally protected and cannot be overridden unilaterally. Furthermore, the land itself was never sold. It was shared under specific conditions which guarantee the continued rights of Indigenous people upon it. In this light, the assertion made by First Nations leadership that the land is not just Alberta's to take does reflect a valid legal, constitutional, and moral position when applied to Crown land governed by treaty negotiations and obligations. Without honoring these foundational agreements, Alberta's claim to sovereign authority over such land would be on extremely shaky ground. In conclusion, prior to conducting my own research, I was far more of the opinion that First Nations had a weak case due to the wording of the treaties and could not demand that separation require their consent, as opposed to simply being consulted. Now I'm not so sure. That said, I now urge you to view the previous video in this series titled, Could Alberta's Separation Actually Lead to Better Outcomes for First Nations? It will show up on the end screen of this video, and I'll also put a link to it in the description for your convenience. In that video, my wife and myself present a case for First Nations being open to considering a deal with a separate Alberta with a view to improving their situations. So thanks for watching and taking the time to think deeply about this important matter. Whether you agree or disagree with one side or the other, the most important thing is that we continue having informed, respectful, and honest conversations about Alberta's future and the rightful place of First Nations in that future. If you found this video helpful or thought-provoking, please click the like button and consider subscribing to the channel so you don't miss future discussions. These things help us greatly. And if you'd like to support the work we're doing here on the Way to Native Chronicles, you can use the Super Thanks button or click the Buy Me a Coffee link that's provided in the video's description below. So until next time, God bless, and I hope to see you in the next video. We're probably not done with this issue yet. Did you like this video? If you did, I think you're gonna like this one right over here. So check it out. And I appreciate your subscribing if you haven't done so already. Remember to do that while you're watching this next video. Click like, it all helps us out for this channel. Catch you next time.